Hey, everybody, thanks for joining us. We're going to just wait a few minutes for people to show up, and we'll start in about, let's say, 3 minutes. Still waiting for a panelist here. We're waiting for Dan, so we'll see. He should be coming in shortly. Has joined us. There we go. All right, I think we can get started. Welcome, everybody, and welcome back to the NSITSP Cyber Series. Today, we're going to mix it up a little bit, and we're going to be doing a panel discussion with my fellow members of the NSITSP Legislative Committee. So we're joined by Ted Geisler, Andrew Crawford, Dan Petrie, and Mark Jennings, myself. And I'll be doing better introductions here in a few minutes. But first, let's just talk a little bit about the Cyber Series, what it is, and where we are today. So over the last year, we just crossed our year mark with the Cyber Series. We've done topics like the NIST cybersecurity framework. We've done CIS framework. We've done what it means to be compliant. We've done shared responsibility models. We've looked at HIPAA and some of the other regulations. So we've covered a lot of topics, and we're going to continue into 2026 covering more topics. Today, as I said, we're covering the cybersecurity safe harbor laws and why they're important to the industry and us in particular. We're going to be looking next month at an update on what's new in the CIS framework. And in March, we're going to be looking at international threats and what impact those are having on the industry as well. So as we build out into 2026, if there are topics that you would like discussed in the Cyber Series, please feel free to drop those in chat today, and we'll see if we can get those on the docket for 2026. One that comes to mind we haven't really touched on at all is AI. It's everywhere. How does cybersecurity fit into AI, and what are some things you need to be worried about? So that's one that I'm going to be putting on the docket. But if there are other topics that we haven't touched on yet, please put those in the chat. Few logistics for today. Again, put your comments, your questions into chat. This is going to be more interactive than most of the cyber series that we've done in the past. So please, if you have a question or a comment that you'd like to make on what the panelists are talking about, just drop that into chat, and we can respond real time, or we may end up waiting till the end of the webinar, depending on the question, what to do today. Now, the webinar is being recorded today. It should be available on the NSITSP website shortly, within a couple of days, and it's available to all NSITSP members. Well, if you're not a member, why would you join? Well, NSITSP, we're an advocacy group. We want to be a voice for the IT service provider industry. If taxation or regulation or registration laws are coming down the pike, we want to know about it. We want to have a chair at the table as legislators are discussing these topics and making sure that anything that comes out of these makes sense for the industry. We also want to make sure that the industry in general really upgrades their professionalism, like doctors and accountants who have to go through meet certain standards or certain ethics. We want to make sure that the entire industry meets a certain standard and really abides by a certain code of ethics so that we can build value and command higher rates with our clients. Finally, we want to build community. We want to make sure that you can learn from experts and view webinars like what you're watching today, and read blogs and understand things that are going on in the industry, where people can do some research and you can basically go and find out the results of that. We also want to share best practices. So become members so that now you can share your practices with others and gain from theirs. So again, if you're not a member today, please go to nsitsp.org/join and join today. So again, today we're talking about cybersecurity safe harbor laws, and I'm joined by fellow panelists and fellow members of the NSITSP Legislative Committee. We have Ted Giesler. Ted has been working in the online IT industry for over 50 years. He ran an IT services business in Chicago area for 25 of those years, and he's been involved in both community and IT community organizing for most of his professional life. Andrew Crawford joins us as the CEO and the voice of truth at Compliance Specialists. His company serves and protects small U.S. businesses from internet criminal data security attacks and helps business owners prevent making themselves vulnerable to business killing events. Dan Petrie joins us as the president of Cloud Solutions Consulting and is an elected member of the NSITSP Legislative Committee. He brings over 25 years of IT and cybersecurity experience to discussions at the intersection of MSP operations, risk, and public policy. Myself, I was a partner in an MSP for 32 years. I left that to found OTX Partners, and I consult with MSPs to help them manage risk and gain compliance with the cybersecurity framework. Most recently, I attained my CMMC certified professional status, and now I work with MSPs and defense contractors to meet CMMC requirements. One final disclaimer before we jump into our discussion. Note at the bottom that this is for informational purposes only. I don't think you see any legal credentials up on the screen today. None of us are lawyers. However, we've been involved in the industry and we're familiar with the lawmaking process. But we are not here to offer legal advice. This is simply a topic of discussion for your information. And if there is anything that you need professional advice for, please consult an attorney. All right. With that, I'm going to stop sharing my screen and we'll start our discussion. So let me frame this up. I'll start with explaining, well, what is a safe harbor law? What is a cybersecurity safe harbor law? Well, the concept of safe harbor law, that is a legal definition where guidance is given within the law as to what is reasonable to meet the law. It expands beyond just the restrictions of the law and says, if you do this, then you will be compliant, or at least you will be largely compliant and you'll be seen as having less liability. So in the case of cybersecurity safe harbor laws, these are laws that just give the judge a reasonableness standard by which they can judge whether or not you've done things to prevent data breaches, whatever they happen to be. Reasonableness is a legal concept. A judge, you see it all the time. You see in detective shows or whatever, or courtroom dramas. What would a reasonable person do, or what is beyond a reasonable doubt? That reasonableness, that is a legal standard, and the judge needs some guidance to understand what is reasonable within any given situation. Now, if you've ever been in front of a judge or in a court situation, most judges are not technically astute. That's not what they do. They don't do cybersecurity. They don't do technology. That's nothing that they're versed in. So they need some guidance. So that's what cybersecurity safe harbor laws do, is they give the judge some sort of guidance to say, well, if you did this, then it's evidence that you took proper measures, you took reasonable measures to secure that data, whatever that data happens to be, whether it's personal health information or protected health information or personally identifiable information, whatever it happens to be. So that's really the basis of cybersecurity safe harbor laws, is to help the judge make those decisions. Now, the other panelists are going to go into other aspects of this. What does that mean? What frameworks do you have to follow? All that. The other panelists are going to go into that. But I want to open it up to discussion amongst the panel about safe harbor laws in general. What are your thoughts?
Well, the key thing I think to talk about safe harbor is that it's designed as a defense against a tort situation. to put that in legal terms, it's if a client is suing you, you have a defense. The key thing behind this defense is that you have to have documented proof that you followed the law prior to the time the incident happened. So if you're in one of the states that have a safe harbor law currently, what you need to do is decide which framework you want to work with, and then start that documentation, have it documented, and in a situation where you get sued by a client or get into a legal battle on a client about an issue, then you've got a active defense. And that it is a defense situation. It does not say they can't sue you. It just is saying this is an affirmative defense. You did the right things.
Right. And one thing that, typically these laws, it's not that you're completely immune from liability. It's that it's taken into account as, if the judge is assessing damages or if the jury is determining whether or not damages should be applied and what those should be. It's again, it's just a guidance. Did you actually do what you say we're going to do in accordance with the safe harbor law? All right. So Ted, tell us about what states have safe harbor laws in already, and kind of how those play out.
Okay. The first state to actually pass cybersecurity IT safe harbor law was Ohio. Um, there were a lot of things that were written into this, and most of the other states, and I'll go into it as I go through each of them, each of the states covered, are all based on this Ohio law. One of the things that they've mentioned in this law is the security requirements can be mitigated by one, the size of your IT firm, the nature and scope of the IT services that you provide, the sensitivity of the data that was accessed, the cost and availability of tools to improve the data security that could have been possibly used, and the resources available to the IT service floor. So even if you're a small single person firm, you have some coverage, and that is taken into effect that you don't have to have a $30,000 a year cybersecurity framework system defined within your organization. You can have something that is trying to follow the frameworks and are following the frameworks um, in what they're trying to intend to cover. It's also interesting to note that you can't just do it once and that's it. Uh, you have 1 year under the Ohio law to conform to changes in your cybersecurity framework. So, for example, if CIS comes out with a new version for 2026, then you have till 2027 to conform with those changes. You can't just use the rules from 2024 in 2027. Um, and most of the states, like I said, are following this Ohio statute. I did not go into putting up, what each of the individual statutes are in a slide, basically because it only determines if you're in that state. So it's giving you a highlight what's going on. I suggest that if you are in one of these states, you go and take a look at the law. The laws are typically 3 to 4 pages long, and they're written in semi-understandable legalese. All of us in the IT business have had to deal with legalese someplace along the line, so you should be able to read it and understand it. The second state I wanted to talk about is Connecticut. Connecticut basically copied the Ohio law, which is not unusual. Only Connecticut gives you 6 months to confirm to changes versus the 1 year that the Ohio law does. Iowa strictly follows the Ohio statute. Utah has no provision for mitigation as they do in the Ohio statute. So it doesn't matter how big your firm is, you are still responsible for whatever could be done. Texas follows the same list of frameworks in Ohio, but they do something totally different. They have they outlined specific mitigations depending on the size of the IT service floor. Specifically, if you have less than 20 employees, 20 to 99 employees, and 100 to 250 employees, you have different rules. Now, it doesn't say anything about if you have over 250 employees, so I'm not sure whether the rule will follow or the law will follow or not, but it's something to take a look at if you're in Texas, to take a look at the law and see what you would have to do to be covered by this law.
Yeah, I think what I've seen is that the Texas law does it caps it at 250, and after 250, it's like lawyer up. Basically, you're on your own because they assume that you have a budget and that you don't necessarily need any kind of protection. You just make sure you're doing the right thing.
In any of these cases, if you're in one of these states that just say using the term lawyer up, I would definitely lawyer up. Get caught in this.
Ted,
Anyhow,
you've been addressing states where MSPs have clients or the MSP locates. Which are you referring to?
it is if the case is brought in that state. Now, that depends on how the case is brought. So it's the location of the particular court case. So
And
if your firm is in Ohio and your client's in West Virginia, it depends on where you brought the suit.
Well, it's interesting. And again, I'm not a lawyer, but a lot of like your contract typically states any disputes will be adjudicated within whatever state typically you're based in. I don't know if that applies if you do cross state lines. Can the plaintiff say, no, we're going to adjudicate it in, my local court? I'm not sure of, but a lot of your contracts typically say where disputes are going to be, and that may be a contract dispute versus a negligence or claim.
What I would say in any case, get yourself a lawyer.
Yep.
No, I think what's important is if you're servicing a client that lives in one of those states, then you may be afforded the protection of the safe harbor law, even though you're not in that state.
That is possible. You could have the case adjudicated either in that state. For example, I'm in North Carolina now. And if I had a client in Ohio, then I could possibly get the case moved to Ohio if they brought it up, and even if the contract brought it up in North Carolina, that said it would be under North Carolina laws. So again, this is getting into touchy legal issues, and I'm not a lawyer.
Yeah.
Next state I want to talk about is Tennessee. Tennessee is kind of interesting in that their law only covers businesses that generate over $25 million in revenue. They figure people underneath that don't need it. It's either $25 million in revenue or control the process and data of over 175 consumers or 250 or 25,000 consumers and derive 50% of their revenue from selling that data. So it's each state has these different little things. Oklahoma is even more different than everybody else. They only cover you for IT cybersecurity problems if you're a hospital or a medical association. If you're not in one of those fields, you're not covered. Now, I should bring up, there's also a couple of states that their legislature has passed laws, but they've been vetoed by the governors. Particularly, there are two. Florida passed the law in 2024, and DeSantis vetoed the bill, stating, as passed, the bill could result in Floridians' data being less secure as the bill provides across-the-board protections for only substantially complying with standards. These incentives do the minimum when protecting consumer data. That was his reasoning. Nothing else has been reported has been working on this bill. West Virginia also had the legislators bill vetoed by their governor back in 2024 also, um, that the unintended effect of the bill is that would be to immunize international entities such as TikTok from lawsuit when West Virginians' personal data and data are shared against our citizens' wishes. The potential for bad actors to abuse this law and to harm our citizens, unfortunately, is real. So there's some play going on as to what is going to be covered with this. There's a lot of things that people are looking at. Um, but that's the current action that is in now. If you're not in one of these states, we really suggest that you meet your legislator, talk to your legislator, and suggest that they take a look at the Ohio law and see if it's something that they could get behind and bring forth as a bill in your state. Mark?
Yeah, and one other thing, and I want to do a shout out to one of our previous presenters, and he's online today. I know he is. I can see his name on the participants. But Mike Semmel sent me a message yesterday saying, "Hey, you might want to know about this federal law that is specific to healthcare organizations or HIPAA covered entities that does provide some safe harbor." It's limited in the sense that it again it only applies to HIPAA covered entities, but also it applies to it only takes into account federally or standards that were enacted by law. So NIST standards, and there's a cybersecurity law from 2015 that applies. But if healthcare organizations or health insurance providers follow those standards, they can get some protection. And in this case, HIPAA violations are adjudicated, if that's the right term, by the Health and Human Services. These typically don't go to a court of law. It's basically the HHS comes in and assesses, what the violation was and what protections were put in place and where you screwed up. In fact, there's a wall of shame you can actually look at and find out all the violations and what the outcomes were. Anyway, Mike let the committee know that there's this other safe harbor law that is actually at a federal level that they can apply. So just to be aware of that. So yeah. So Andrew, tell us. Okay, now we know that these safe harbor laws exist. We know that they exist in different states. Can you dig into that and tell us, what these laws require, how how they're phrased, and how you would prove potentially in a court of law that you qualify for safe harbor under the law?
Well, it all boils down to what I refer to as the Achilles heel of small business. That's documentation. As far as the government or any auditing entity is concerned, if it's not documented, it doesn't exist. So this is where the MSP can get caught if they aren't doing good documentation. So let's pick an example of something everybody knows and is very familiar with, multi-factor authentication. The question from the auditor would be something like, show us that all devices have multi-factor authentication on them. Well, when they mean all, they don't mean just the PCs. They mean everything. Well, I'll bet you have a printer that doesn't have multi-factor on it, because not too many printers do. Is that documented in your documentation that we checked, it's not available, so this is the best we're able to do? That shows that you managed the system. But if you provide a list and they look at it and say, where's the printer? You've already failed. And especially if it was the printer that the breach came through. So documentation of processes, procedures, how do you do things? How do you offboard the client as the MSP? Do you have that documented? This is the procedure we follow, and these are all the things we check. That kind of documentation is rare. And when compliance comes in and says, you need to do this, it's a culture shock. And it is a ongoing process to get people to not only document things, but to keep it updated.
So how do I know what I need to document?
The word everything comes to mind.
Well, I'm kind of leading into so we haven't really explained to the audience, what's in these laws, and what do they consider compliance. So what I wanted to do here is just kind of show the audience, what is it, what are the safe harbor laws saying? If you do this, then you get protection. And so this is a list of the different frameworks that are called out specifically in these laws. Now each of these may not be in all of the laws. I think there are some that are specific to one or the other, but these are examples of the frameworks that that you can follow. And again, these frameworks to tell you, for access control, these are the things that you need to do. And that's where, from Andrew's perspective, well, okay, how do I prove that I did what the standard says? Well, you document it. You have everything documented, and all of your processes and procedures are, take into account what's required by the framework. So I just want to make sure that the audience sees, this is really what the laws are. This is the standard by which they're telling the judge if they do this, then they've taken reasonable steps.
And don't be surprised if your client doesn't fall under more than one of those.
Right. Now, if okay, now we know that we've got a guideline to follow, we've got a framework to follow, we've documented that and all that. How would that play out in court? How's the judge going to know? Okay, you say that you follow these processes called out by NIST, CSF,
Well,
whatever it happens to
they
be.
won't let you speak to it. They're going to have a third-party auditor come check. And the auditor is going to use those standards.
Right.
And they're going to say, yes, the MSP followed this one. No, they failed on this one. And down the list they will go. Or they will say the MSP was unable to provide any indication of compliance. And unfortunately, in this kind of thing where the charge is that you were negligent, you're guilty until you can prove that you're not.
Right. Right. Yeah. And to Ted's comment earlier, you have to prove that you were compliant prior to the breach. They're not going to do a point in time. Okay, the breach happened 2 years ago. Go and check out what you're doing now. They're going to say, okay, show me the documentation from that time of when the breach happened. Show me your log files. Show me your process and procedures. Show me, in your ticketing system how you handled the situation at the time of the breach, and make sure that that was in compliance. Great. So, anybody else comments, questions
You
on,
you
okay.
raised an important point. The lawsuit may follow sometime later when
Right.
somebody is looking at it and finally decides, you know what, that MSP wasn't doing their job a year ago.
Right.
How much documentation do you have from a year ago, 2
Yeah.
years ago?
Yeah. In fact, lawsuits take forever to get through the system. So it's unlikely that you would be in front of a judge or a jury, any sooner than maybe a year or maybe longer, depending on the complexity of the case. But these things don't happen quickly. And so, you need to make sure you're preserving evidence. Um, I have in my past experience been an expert witness on a technical issue, and it's amazing the amount of evidence that you have to go through to frame up your argument or to frame up your assessment of the situation. So,
And
And one of the things,
transmission.
oops, just be advised, default settings aren't enough.
mhm,
one of the things to mention about this, it might be after the former client is no longer your client, and this was pointed out, is by their new IT professional that this previous firm was incompetent and that they were responsible for what the problem was.
Right. And given the cyber insurance industry as well, lawsuits are going to be on the rise. Cyber insurance is a big thing. Guess that client's cyber insurance provider is probably going to look for recourse from you, the MSP, because they don't want to be on the hook to pay for this. They want your cyber insurance to pay for it. So, um, uh, basically, and the other thing we talked about this in committee the other day is that now because cyber breaches are becoming so well known, they're publicized. The liability, I'm going to use the term, and it's a derogatory term, but the ambulance chasers or the personal injury lawyer industry is really jumping on this and filing class action lawsuits because, hey, that's a well-known breach. There were thousands of victims all in one swoop. It's a great opportunity. So you're going to see more and more of an increase on the legal aspects of cybersecurity.
And most of the lawsuits are filed within 2 days of the breach being announced. It's gotten very fast.
Yeah, exactly. All right. So we're talking about this, and we've discussed the fact that there are only 6 states that actually have full laws in place. Am I correct on that, Ted? You're on mute.
Excuse me, I missed that. I was reading something in chat.
So what we're identifying is there are 6 states or so that have cyber security safe harbor laws in place today, and NSITSP is taking a position where every state should have some sort of cybersecurity safe harbor, because obviously we want people to do the right thing. We want people to follow a standard, whether it's CIS or HIPAA or CMMC or whatever it happens to be. Just follow a standard and do things the right way. And to do that, we want them to offer incentives like this. This is a carrot rather than a stick of some form of regulation. Thou shalt do this, or you'll be out of business. So we really want to send the message to states on how to enact these laws and what other states they can look to. Yeah, Ted mentioned Ohio. Just go look at Ohio's. That seems to be the model legislation for most of the other ones. But Dan has joined us today to really talk about how do you engage with your local legislators to promote this idea of getting a safe harbor law in your state. So I'm going to hand it over to Dan here for that discussion, and we do have some slides to show. So I'm going to share my screen again.
Thanks, Mark. Can you all hear me okay?
I can hear you.
So while Mark's getting that on screen here, I just want to echo the point about the carrot and the stick. So that's one of the things that makes safe harbor compelling for legislators really across the spectrum, the political spectrum, is that this is a carrot, it's not a stick. So we're not asking for new regulations or compliance mandates. We're just saying, hey, reward businesses that are proactively investing in cybersecurity. So I'd say for business focused legislators, this protects companies without adding costs. And for legislators that are more focused on like the consumer protection, then the message is that this incentivizes better security practices within the MSP space. So, for everyone, it kind of demonstrates that our industry is really willing to self-regulate through the voluntary adoption of different controls. So I'm going to step through here some 4 simple steps to really engage with your legislators. And the first step is to look up and find your legislators. There was a website named openstates.org. You might still find a reference to that on our website, but that redirects now to the URL that's on the screen. And you can search for your legislators there by entering your address. And what you want to do is, note your legislators committee assignment. So particular relevance here are if they're on a committee, the Commerce Committee, the Technology Committee, or even the Judiciary Committee. And then next, you want to start making contact. Now, here we're talking about calling their office. This can be an effective way to get initial contact, but one of the main things here is that you want to introduce yourself as a constituent at first, not necessarily as an advocate or to be perceived as a lobbyist, but as one of their constituents. Now, you certainly want to introduce yourself as an IT professional as well, and then eventually, mention your membership of NSITSP. But in your initial engagements with your legislator, you want to offer yourself as a resource when it comes to their need for expertise around cybersecurity or technology issues. And that's a really effective way at establishing that relationship. Now, calling their office is one way to start. There are other strategies to engage with legislators. You could attend events such as city council events. You can, in those initial phone calls to your legislator's office, you can learn where your legislators may be in terms of events so that you can attend those events. Because oftentimes it's those in-person connections that's really going to start developing that relationship. And also, one of the key strategies that I've learned is that when you want to develop with the relationships with legislators, you often want to develop those relationships with their supporting staff. So at those events, you get to understand who their staff members are, what roles they play, and create those relationships there. But once you do start to develop a relationship, then you can, merge into introducing the safe harbor laws. You can say things like several states have passed cybersecurity safe harbor laws that reward businesses following best practices. You can develop yourself a script that sounds natural. But you can ask them at that point, has anyone brought this to your attention? So that starts to open the door to engagement. And then lastly, you want to have like follow-ups, because this is really about building a relationship, developing trust, becoming a resource, like I mentioned earlier, as an expert in the field. So that has multiple benefits, not just to your position in the local community, but it develops that trust. So, you can also, I mentioned attending like local city council events. For some of your state and federal legislators, oftentimes it's more difficult to engage with them directly, but you can find out if your state or your local commerce, if there are legislative days basically to attend, because your chambers of commerce will generally oftentimes coordinate legislative days where the community come out and meet your legislators. So we can move on to the next slide.
Great. And just a little commercial break. Nicole has put into the chat that you can also join us in our legislative committee meetings. Even if you're not a member, these are open to the public. So if you go up on our website and you can see when the meetings are and you can get a link to the meetings, join us. If you want to interject some thoughts into one of them, please join us and help us continue to push this effort.
That's a great point, because this is great introduction to the content, but if you attend those meetings, then you can continue the dialogue and kind of nurture like the mindset and the guidance there. So on this next slide, there's some key talking points that you can use in the conversations with your legislators. You don't need to memorize these word for word, but they give you a framework. So something like the proven model there point is very powerful, because you're not asking these legislators to experiment, you're demonstrating that these are proven effective policies in other states. When you mention something like the rewards good actors, then you're again emphasizing that there are no new compliance costs. The protect small businesses generally resonates with folks, because especially local legislators are going to be thinking about how small businesses are basically the backbone of local economies, right? When we talk about improved security and creating market incentive, I think all of us can agree that having conversations around improving security posture with small businesses, they seem to understand that that's something that is a real issue, but don't oftentimes prioritize it. So this is a way to incentivize that. And lastly, you might want to adapt these to your particular state's context. So if your state has strong ties to maybe a particular industry like financial services or manufacturing, you can, emphasize how Safe Harbor protects those particular businesses when you're having those conversations. Any other talking points the committee wants to add? If not, we can move on to the next slide.
Oops.
So there are some resources on the NSITSP website that can give you some additional guidance. There's a guide on, contacting your state representatives. There's information on the overview of how bills become law if you want to have a little bit of context before you start engaging these, people who are in that field. But just remember, kind of how was mentioned earlier, like the legislative committee is here to support you. So reach out to us if there is interest in actually proactively engaging, because this is a really key component of kind of our work efforts and representing our industry. But these are downloadable from the website. If you go to the resources tab, you'll need to log in and you can download these resources. We can move on to the next slide. So I just want to close out with maybe a particular challenge here, which is do one of these things. All right, go to the website on the screen, look up the representative who's representing you, and make that phone call to introduce yourself. You don't have to pitch the Safe Harbor law again on your first call, but take that step to start establishing yourself as a resource. And then whatever it is you do, whatever action you do take, please let us know. Join our meetings, because it's important for us to know if you're out there reaching out to your legislators, so we can think about how we can coordinate with you and provide support. And then also that we can start thinking about how we can track all of our collective progress across the states. So with that said, are there any questions around contacting legislators or local policymakers?
While we're on this topic of legislators, I'd like to bring up a fourth point that'd be useful. If you could keep track of what type of laws are coming out of your state legislator, anything that would affect the IT business and your particular business, please let us know. We had a case in November where there was a state legislator that was trying to outlaw internet pornography in a specific state. And in the process of doing that, he also wanted to outlaw VPNs, proxy servers, and any way to get around this law for disallowing access to internet pornography in that state. Of course, it has a lot more ramifications than just the pornography question. So the point is that the legislators in general are typically not IT professionals. They have very little understanding in general of what IT things do. So they have a tendency to not realize the ramifications of what they're really what they're really writing in laws. And unfortunately, once a law gets passed, it's the words that count, not the intention. So it's
Really
one of those
important.
things. If we can get ahead of it and let us know, we will do our best to bring out the positions and bring out that we're against this, and us as representing the MSP community are against this particular position. But that's part of what we're doing. We want to proactively come and push Safe Harbor, but we also have to be reactive to what's going on in the state legislators. And the five of us that are on the committee can't watch every state. It's just not possible.
I think that it's a good example of like the importance of how the more of us who build these relationships, then the more influence we have as an industry in what these legislators are determining are important for the business. So as you mentioned, the more we're not aware of what's happening if we're not having these conversations, and sometimes it's a little bit reactive because we don't have the representation there.
So Mike Semmel has dropped into chat. The National Conference of State Legislators has a tracking site for laws that I know we were looking at a Pluralsight. There was another one that we had looked at before that was a product for this, but this looks like a common site for state legislators to track laws. So take that that URL and bookmark that because it looks like a great resource for this.
We have been, as a committee, we have been trying to follow these. Unfortunately, when you have a law like the one we saw back in November that has nothing to do with IT, but buries something inside of it. So it's one of those things, if you've got it, we can't just take a look at what the law says it's going to be, but rather what the law really says.
Right.
California has been mentioned by one of our former members of the committee that what they do is they have a period of time in the beginning of the year that they're allowed to put new bills out, and they'll name it one thing, and then by the time they actually get to using that placeholder for a bill, it'll be a completely different thing.
Right.
So you can't necessarily just watch what's there. You've got, if we can get people that are paying attention to what's in these bills, that would be appreciated.
Yeah, I think that was definitely drawn out in the one that we were looking at. That you, by the name of the law, you never would have guessed that they were trying to outlaw VPNs and proxy servers, but buried in the language, it's there. It's very obvious once you get in. But yeah, good counsel there. So
Well, and,
um,
and I just want to, not to beat a dead horse about relationships with legislators, but to bring it back to that point, because things are buried in there, sometimes when legislators or their staff members know what you're concerned about, they'll proactively inform you, like, hey, this may not be obvious, but by the title of the law, but there's some information in here that you need to be aware of.
yeah, yeah, it's all about relationships. All right. Let's see, just double checking to see if any other questions have come up in the chat. Doesn't look like anything else. Any final closing comments from our panelists today in terms of um, what to do about safe harbor laws?
Whether there's a safe harbor law or not, document.
Yeah,
Get going on your documentation.
right.
There's one comment that Mike Siegel made early. In theory, every state has a safe harbor, if a defendant can prove they consistently implemented a recognized framework, et cetera, et cetera, et cetera. The point about here and the difference between what we're doing and it rather than just that, what we're trying to push is a safe harbor law that has an active defense position. So, such that you can say, we followed, according to the safe harbor law, we followed this, and this suit is non-viable suit. And we can prove that we did this. It's not where you now going into a situation of, did you do this? Did you do that? And well, this could have been done differently. Why didn't you do it that way? Rather than going to that you followed the framework and did what was required by that framework, it takes out a lot of the why didn't you do this in addition to that type question.
Right. Yeah, and I think the interesting thing is we put a pretty long list of frameworks that you can follow. That again, depending on the state you're in, one may or may not be in the list. But there are ones that I don't see in any of the lists that exist, and people I think there's one called SMB 100, which is starting to get a little bit of buzz in the small business community. That's not on any of the lists that I've seen, and would you, if you went into a thing and say, well, we follow SMB 100 and we can prove it, is the judge going to know that that's an appropriate or reasonable approach? I don't know. I mean, that's really a legal question, and it's going to be up to the expert witnesses and the whatever the defense and the offense use in the case. So, yeah, I mean, it's actually one of the other questions that I did want to chat about is, and this I think falls under Andrew's topic is, have any of these actually been challenged in court yet or been invoked in court yet? And I know Andrew has.
I think Andy disappeared, but
I
can partially answer that question. I don't have it at my fingertips, unfortunately, but these laws are new. The Ohio law, which was the first one, was passed in 2024. So there is a year of experience under this law. There have been several cases in Ohio that have referred to this law. I believe the number was 3. So you don't have a whole lot of case history here that has affirmed this. None of them have gone to actual trial. What happened was they went in, that was the basis for negotiation, and they came up with a deal beforehand. So by having this, you're avoiding the cost of the trial and those particular things. That's what we've seen. So that's what I've seen so far. And this was from this was from one of the law organizations. I'm not sure if it was the ADA, the local bar for Ohio or not, but that was part of it. There's only been 3 or 4 cases at this point that have fallen underneath it. So is there a consistency under this? We don't know. It's
Right.
too new.
Right. Yeah. And I think the bottom line is, this safe harbor law or not, following a cybersecurity framework as an MSP or as an IT service provider is so much better than just, pot shotting it. Well, we're going to use this for, this is how we're going to do our antivirus, or this is how we're going to do, our SIEM system or whatever. Just by kind of doing it off the cuff is not ever going to play well, in court, but also just it's not a very structured way of approaching cybersecurity. I mean, we're at a point where we have to take a structured approach to cybersecurity. And, honestly, I don't really care which framework you follow. If you're following a framework, then you're actually, you're doing the right thing. You're not just pot shotting it. So, yeah. I don't see any other questions in the chat. Any other final comments from the panel?
Mark, I might just mention for those of our members who are in a state that already has a safe harbor law, that's great news. Become familiar with it, but also track to still building a relationship with your legislators, because you can still keep an eye out on what proposed changes may be coming up to that law, or if new laws are getting introduced that might overlap or conflict with that existing law. And you might also be prepared for some of the activities that this committee might be coming out with in the future. So I just wanted to touch base on some of those folks who might also be in a state that has an existing law.
And I'd also like to push as we keep on saying it, is joining the organization, because the number of members we have makes a difference. A case that happened in Maryland last year was Maryland has a constitutional position that they have to have a balanced budget. So to balance their budget, what they originally had defined to do was a tax on all service providers in the state, kind of essentially a sales tax on service. What happened was that the lawyers, the doctors, the accountants, and all the rest of that went and took their lobbyists, and they, in the last week or 2 that they had to pass this law, they changed the law to they're only going to bill for IT services and cloud services and things along those lines. So then the IT people got hit with the coverage rather than what they were trying, what originally was put across for the law. If we can build our organization and have enough people and have enough names behind just saying a national society, then we will be actually to be able to do that type of lobbying that the others have done. And that's part of the reason for going in and doing joining the organization.
Yeah, good call, Ted. Yeah, that's absolutely the more voices we have, the better. So yeah. All right, great. Well, with that, I'm going to start wrapping this up. I do have one more slide to show, which is what do we have upcoming in the cyber series. And basically, so In February, we're going to be doing an update on the CIS cybersecurity framework. So we're going to have Phyllis Lee from CIS come on and tell us what's new. She presented last year around this time on the CIS cybersecurity framework and why it makes sense for certain organizations. And then, whoops, in March, we're going to look at international threats. What are we seeing on the international threat landscape and what can we do about it? As I mentioned at the beginning, if you have any other topics that you would like us to discuss, please send us a note. Let us know what you're interested in. I will work on getting some speakers lined up for those topics. And with that, I'm going to wrap this session up and hope to see you again next month.
Thanks, Mark.
Thanks, everybody.